In the last chapter, you focused on contracts, how offers become binding agreements, what makes a contract valid, and what happens when someone does not perform. Agency law answers a different but equally important question: who you are working for and what you owe them. Every listing, buyer-broker agreement, or property management agreement is both a contract and the foundation of an agency relationship. Contract law tells you whether the agreement is enforceable. Agency law tells you what duties you owe once that relationship exists. At the heart of agency is trust. The principal relies on the agent to act with honesty, loyalty, and competence. The agent accepts that trust and undertakes to protect the principal's interests, even when that is inconvenient or conflicts with the agent's own interests. That is why agency is described as a fiduciary relationship. It is more than just helping someone with paperwork. It is stepping into a legal role where your actions, promises, and omissions bind someone else. An agency relationship does not require compensation. A principal can owe you nothing, and you can still owe them full fiduciary duties if you have taken on the role of their agent. Likewise, compensation alone does not create agency. A third party may pay your commission, but if you are representing someone else, that someone else is your principal, not the one who wrote the check. Basic roles in agency. Every real estate transaction involves at least 3 roles under agency law, even if one person wears more than one hat. The principal, or client, is the person you represent. The principal can be a seller, buyer, landlord, or tenant. The principal hires the agent and is entitled to fiduciary loyalty and advocacy. The agent is the person or firm authorized to act on behalf of the principal. In real estate brokerage, the broker is the agent. Salespersons and associate brokers act on behalf of the broker. When we casually say the agent represents the seller, legally it is the brokerage that is the agent of the principal, and the licensee is the broker's representative. The customer is the third party in the transaction who is not represented by that particular agent. A buyer working directly with a listing agent is the listing brokerage's customer. A landlord reviewing an application from a tenant represented by a tenant's agent is a customer of that tenant's brokerage. The agent must treat the customer with honesty and fairness and disclose known material facts, but does not owe the customer fiduciary loyalty. When you hear principal, agent, and third party, you should immediately think client, brokerage, and customer in the real estate context. Levels of authority. Universal, general, and special agency law recognizes different levels of authority that a principal can grant an agent. Real estate licensees mostly operate at the most limited level, but it is important to understand all 3. Universal agency gives the broadest authority. A universal agent can perform any and all acts that can lawfully be delegated, such as handling personal finances, signing legal documents, and making legal decisions. This level of authority is usually created by a power of attorney, often in a guardianship or estate situation, not in ordinary brokerage. Real estate agents almost never act as universal agents. General agency authorizes the agent to handle ongoing matters within a particular business or enterprise. A property manager is a classic example. The owner, principal, may authorize the management company, general agent, to advertise, lease units, collect rents, pay expenses, and even sign certain contracts on the owner's behalf. A salesperson is also a kind of general agent of the employing broker within the brokerage business. Special or limited agency is the form most common in residential brokerage. The principal grants the agent authority to perform a specific task or handle a specific transaction, such as listing a property for sale or representing a buyer in the purchase of one property. The agent's authority is limited to what is written in the listing, buyer-broker, or similar agreement. A special agent usually cannot bind the principal to contracts beyond that scope. For example, a listing broker typically does not have authority to sign a purchase contract on behalf of the seller. The seller signs their own contracts, Most traditional listing and buyer-broker agreements create special agency. The broker is hired to procure a ready, willing, and able buyer or seller under defined terms. Once that objective is met and the agreed-upon term expires or the transaction closes, the special agency relationship ends, although certain duties, such as confidentiality and accounting, survive. How agency relationships are created. Agency does not always arrive with a neat label and a signed contract. It can be created expressly, implied by conduct, or shaped by necessity, apparent authority, and later ratification. All of these are important for a real estate licensee who wants to avoid accidental clients. Express agency is created when the principal and agent explicitly agree, either in writing or orally, to the representation. A listing agreement or buyer-broker agreement is an express agency contract. The document sets out who the principal is, what the agent is authorized to do, what duties are owed, how and when compensation is earned, and when the relationship ends. In Arizona, brokerage relationships are generally reduced to writing, both for clarity and compliance. Implied agency arises when the parties act as if an agency relationship exists, even though they never formally agreed or wrote it down. The key is conduct that would lead a reasonable person to believe that the agent is representing the principal. For example, if you tell a buyer, "I will work to get you the lowest possible price and protect your interests," show them property, analyze comps solely for their advantage, and negotiate directly on their behalf, you may have created an implied buyer-agency relationship, even if the buyer never signed a buyer-broker agreement. If that buyer later pays you a fee, or you accept compensation tied to that representation, the existence of implied agency is even harder to deny. Once implied agency exists, the full package of fiduciary duties follows. If you then act against that buyer's interests or fail to disclose a known material fact, you can be liable for breach of fiduciary duty, even if you thought of them as only a customer. This is why many brokerages strongly encourage or require written agency agreements. It reduces the risk of unintended relationships and clarifies who is owed what. An agency of necessity can arise in urgent situations where immediate action is required to protect the principal from loss, and it is impossible to obtain instructions. 3 conditions are typically present. The agent cannot contact the principal. Action is necessary to prevent loss, and the agent acts in good faith. Although this concept is more common in medical or financial emergencies, a simple example would be a property manager authorizing emergency repairs to prevent serious damage when the owner cannot be reached. The law recognizes that, in emergencies, an agent may need to act first and explain later. Apparent authority, ratification, and estoppel. In addition to express and implied agency, the law looks closely at apparent authority, how things look to third parties. Apparent authority exists when a third party reasonably believes, based on the principal's behavior, that an agent has authority, even if the principal never expressly granted it. If a broker allows an unlicensed assistant to sit in a model home and behave like a salesperson, buyers may reasonably assume the assistant has authority. The principal can then be bound by the assistant's statements or promises, even though the assistant legally should not be doing that work at all. Ratification occurs when a principal accepts and benefits from an unauthorized act, thereby making it binding after the fact. For example, if an assistant or salesperson without authority enters into a small contract on the principal's behalf, and the principal accepts the benefits without objection, the principal may be held to have ratified the act. In real estate, this might look like a seller accepting terms negotiated by an agent who exceeded their authority, then later trying to disclaim the agreement. The principal's acceptance can make the act binding. Estoppel prevents a principal from denying agency where the principal's conduct led a third party to reasonably believe the agency existed and rely on it. If a broker allows someone to routinely negotiate and sign documents as my representative and never corrects that impression, A court may hold the broker as stopped from denying that the person was an agent when things go wrong. The practical lesson is simple. Be precise about who represents whom. Document agency in writing. And do not allow others to appear to have authority they do not actually possess. Types of representation in real estate practice. Within brokerage, courts and statutes also focus on who you represent in a given transaction. A seller's agent, listing broker, is hired by the owner of real property to market the property and negotiate a sale or lease. The broker's fiduciary duties run to the seller: loyalty, obedience within lawful instructions, reasonable care, confidentiality, disclosure, and accounting. The listing agent works for the seller and with buyers as customers, unless a separate buyer-agency relationship is created. A buyer's agent is engaged by a buyer to locate and help purchase, exchange, or lease property. In many MLS systems, the buyer's agent is sometimes referred to as the selling agent because that brokerage brought the buyer who ultimately purchased the listing. A buyer's agent owes full fiduciary duties to the buyer, even if the seller is paying the commission. Dual agency arises when the same broker represents both buyer and seller in the same transaction. This can occur directly, one licensee is working both sides, or through designated or intra-company agency, where one brokerage has one agent with the listing and another agent with the buyer, but the broker of record still sits in the middle. Dual agency is inherently conflicted because the broker cannot fully advocate for both sides at once. For that reason, Arizona requires informed, written consent to limited dual representation before the dual representation occurs, not after an offer is already on the table. In a limited dual representation agreement, the broker discloses that they cannot disclose certain information without written authorization, such as how low a seller is willing to go or how high a buyer is willing to go. They must remain neutral on some key points and cannot favor one party over the other. If a broker becomes a dual agent on the first offer, they cannot disclose that offer's price or terms to compete with a second buyer. Doing so would harm the first buyer and violate the consent to limited representation. This shows how carefully information must be handled when the same brokerage is in the middle. Agency and the employing broker. In Arizona, a licensee may only perform real estate services for the employing broker with whom they are licensed. A salesperson who moves from broker A to broker B cannot continue to service a listing that remains with broker A while collecting commissions through both. ARS Section 32-2153 and AACR 4-28-306 make it clear. All licensed activity must be conducted through your current employing broker. Unlicensed assistants are further limited. A DRE policy prohibits them from holding or hosting open houses, answering detailed property questions, or unlocking model homes for unaccompanied buyers. These tasks can easily cross into licensed activity and mislead consumers into relying on someone who is not properly authorized or supervised. Article 26 of the Arizona Constitution allows licensed brokers and salespersons to draft and complete transactional documents without charge as part of acting as an agent in a sale, lease, or similar transaction, even if the property is not in the MLS. If an owner has already found a buyer and simply asks a licensee to draft and negotiate the purchase contract on the owner's behalf, that licensee may do so as long as they are representing a party to the transaction and are operating through their employing broker. If they are not representing anyone, they may not prepare those documents at all. Fiduciary duties and disclosure in Arizona. Because agency is fiduciary, the agent owes duties beyond simple honesty. Arizona's commissioner's rules, particularly R4-28-1101, spell out many of those duties and prohibitions. In broad terms, a broker must protect and promote the client's interests, disclose known material defects, act expeditiously, and provide services that match professional standards of practice and competence in the specific real estate discipline. The broker must exercise reasonable care in obtaining and communicating information, help clients verify information when appropriate, and recommend legal, tax, accounting, and insurance advice when the situation calls for it, especially in risky scenarios like pre-possession or post-possession. Brokers are prohibited from allowing disputes with other brokers to interfere with a transaction, from acting in a transaction without disclosing personal or family interests, from accepting compensation from more than one party without written consent, from acting as a dual agent without written consent, from taking side compensation without disclosure, from practicing outside their competence without help or written disclosure, and from allowing occupancy or early possession without written authorization or before closing without the seller's express instruction. These general duties translate into more specific agency disclosure rules. A listing broker must present all offers, disclose if a buyer appears unable to perform, disclose if the broker or their family or a business entity they own is the buyer, disclose side compensation or rebates, and identify all employing brokers receiving compensation. A buyer's broker has parallel duties toward the buyer. Disclose known material defects, warn if the seller seems unable to perform, flag possible liens or encumbrances, and fully disclose their own interests and compensation arrangements. Because disclosure obligations are extensive, brokers are encouraged to follow practical guidelines. When in doubt, disclose. Point out suspicious conditions and recommend investigation. Verify or help the client verify information when its accuracy is in question. Identify information sources. Use standard disclosure forms like the seller's property disclosure statement. Recommend professional inspections. Educate clients about their own disclosure and investigation duties. And critically, document everything in writing. Note that not every piece of information is a fact materially affecting the transaction. For example, an appraisal ordered by a lender is primarily an opinion of value for lending purposes. Even if the seller pays for the appraisal, the lender is the appraiser's client, and federal law requires the lender to provide the appraisal to the buyer, not the seller. The buyer has no automatic duty to give that appraisal to the seller simply because the seller paid the fee, and an appraisal itself is not a material fact about the condition of the property. That distinction, fact versus opinion, is important when deciding what must be disclosed. Principal and agent, a simple illustration. To make these roles less abstract, imagine a small business, Barks and Bubbles, a pet grooming shop. The owner authorizes an employee to order supplies. That employee is the agent. The owner is the principal. When the employee orders 500 rawhide bones from a supplier, the owner and business, not the employee personally, are legally responsible for paying the bill, as long as the employee acted within their authority. The agency relationship is fiduciary. The employee must act in the owner's best interests because the owner is bound by the employee's actions. Sometimes this is created by an express agreement. Please order supplies for me. Sometimes it is implied by conduct. An employee left in charge routinely ordering inventory. Apparent authority arises when the owner's behavior leads suppliers to reasonably assume that an employee can act for the business. Ratification comes into play if the owner accepts benefits from an unauthorized order. Estoppel can prevent the owner from denying agency if they allowed an employee to appear to have authority and did nothing to correct that impression. Real estate brokerage works the same way. When a seller hires a brokerage, the broker is the agent, the seller is the principal, and buyers and other third parties are customers. Everything the licensee does within that scope can bind the principal, and the licensee must remember that their authority and obligations flow through the employing broker. Terminating the agency relationship does not last forever. It can end by the acts of the parties or by operation of law. Once it ends, the agent no longer has authority to act, and the principal should notify anyone who dealt with the agent so that apparent authority does not linger. By acts of the parties, agency can terminate when the agreed purpose is achieved. The property sells, the lease ends, the management agreement is completed, when the stated term expires, or when one or both parties withdraw consent. The parties may mutually agree in writing to cancel a listing or buyer-broker agreement before expiration. The principal may attempt to revoke the agent's authority, or the agent may renounce the relationship by refusing to continue acting. However, simply walking away does not erase all obligations. If a licensee unilaterally terminates agency before fulfilling contractual duties, they may be liable for breach of the agency agreement. A seller who demands cancellation mid-listing may still owe reimbursement for marketing costs, or even a commission if the broker produced a ready, willing, and able buyer during the listing term, or within a protection period. Tail clause. By operation of law, agency can terminate automatically when certain events occur: the death or permanent incapacity of a party, bankruptcy that affects the subject matter or ability to perform, destruction or condemnation of the property, impossibility of performance, frustration of purpose, or subsequent illegality. For example, if the listed property is destroyed by fire, the listing agreement no longer has a subject property and the agency ends. If the property turns out not to be owned by the purported seller and they cannot convey title, the purpose of the agency is frustrated and must end. If a broker's license is revoked, that broker cannot continue to act as an agent for any principal. Whenever an agency relationship ends, the principal should promptly inform third parties who have been dealing with the agent. Until that happens, those third parties may reasonably assume that the agent still has authority, and the principal could be bound by the agent's subsequent actions through apparent authority. Review summary. In this section, you shifted from contracts to relationships. You learned that an agency relationship is the legal connection between a principal and an agent, built on trust, confidence, and fiduciary duty. The principal may be a buyer, seller, landlord, or tenant. The agent in real estate is the brokerage. The customer is the unrepresented third party in the transaction. You saw that agency can be universal, general, or special, with real estate brokers almost always functioning as special agents for specific transactions. Agency can be created expressly by written or oral agreement, implied by conduct, or arise in necessity. Apparent authority, ratification, and estoppel show how a principal's behavior toward third parties can create or solidify agency even without clear words. You examined common forms of representation in real estate: seller's agents, buyer's agents, and dual agents, including intra-company dual agency, where separate agents represent each side within the same brokerage. You learned that dual agency in Arizona requires prior informed written consent, and that a dual agent's duties of loyalty and confidentiality are limited to protect both parties. You reviewed critical Arizona rules that require licensees to work only through their employing broker, limit what unlicensed assistants may do, and permit licensees, under Article 26, to draft transaction documents for parties they represent. You walked through the fiduciary duties imposed by the Commissioner's rules, including protecting and promoting the client's interests, disclosing known material facts, acting competently and diligently, and avoiding undisclosed conflicts or improper compensation. You saw how disclosure duties differ for listing and buyer's brokers, and how practical guidelines, when in doubt, disclose, document everything, recommend professional inspections, help keep you in compliance. You also clarified that opinions, such as appraisals, are not the same as material facts, even when the seller pays for them. Finally, you studied how agency relationships end. They can terminate by acts of the parties: performance, expiration, mutual agreement, revocation, or renunciation, or by operation of law. death, incapacity, bankruptcy, destruction, impossibility, frustration, revocation of license. Termination does not erase all obligations. A wrongly terminated agency can create liability, and principals must notify third parties to prevent lingering apparent authority. Understanding agency law is essential to practicing real estate safely and ethically. It tells you not just how to write contracts, but who you are truly serving, what you must disclose, how far your authority extends, and when your relationship with a client begins and ends.